I did have some opening remarks regarding the recent proposals by the Minnesota Sentencing Guidelines Commission. Last month, we began to discuss Sentencing Guidelines Commissions and recent actions that they made. We were only considering whether to require in a previous bill confirmation of members of the commission and the process that the commission uses. Today we're here to actually discuss the actions of the commission took between November and January, and also on the topic of probation. But I'd like to review a little bit of the chronological events that occurred in the last few months. On November 5th, a probation discussion item was added to the Sentencing Guidelines agenda on November 5th. On November 6th, the Department of Corrections Commissioner Schnell brought forward a proposal to cap probation at 5 years in most cases. At that time, there were objections in that discussion. On December 12th, 6 days later, one commission member moved to rescind the commission's November 6th vote to approve a public hearing. Several memos were written objecting to that product. On December 13th, after the November and December hearings, the commission requested an opinion from Attorney General Ellison on whether they had the authority to do what they were doing regarding probation. A public hearing took place anyway on December 19th. On January 8th, the commission received notice from the AG's office that the proposed amendment, although the commission had authority to look at probation limits, the proposed cap had exceeded their authority according to the Attorney General's office. Specifically, the proposal removed discretion from the courts, which violated statute, the very nature of the guidelines, and posed a potential constitutional separation of power challenge. Attorney General Ellison was quoted by saying, by imposing a mandatory 5-year cap on probationary sentences, the commission exceeds its legislative authority and encroaches upon judicial authority to impose appropriate probationary periods up to the statutory maximum. A modification to the November and December proposal was apparently issued on January 2nd, and it was amended further throughout the course of the commission meeting to adopt the proposal on January 9th. I would like to make a comment that I've made before. One of the purposes of the commission is to take the time that the legislature cannot and use a greater level of criminal justice expertise that it has in its members. And oftentimes that's even more than the members of the legislative body that we belong to. And to bring forward through thorough and well-vetted changes to the guidelines. Since the January meeting, despite several well-seasoned members of the commission who objected, the commission continues to send us letters on the topic. Some of the members or other proponents of probation reform could have brought forward their proposals as early as June of last year instead of moving directly forward in the last 2 months in a deliberative movement to accept the guidelines that they proposed. I would like to first visit on the commission's statutory mission that gives them the justification for their organization. Under proposed guidelines that modified limit probation terms, Commissioner Schell quoted, "It is the duty of the Sentencing Guidelines Commission to ensure uniformity, proportionality, rationality, and predictability." He actually quoted from Minnesota Statute 244.09. As I looked at the decisions and the proposal that Senator Schnell offered. I believe, did I say, I called him a senator? My apologies to the commissioner. I believe uniformity was addressed, but I'm not so sure about the proportionality, rationality, and predictability. I believe in the haste for addressing the uniformity issue, the majority of members missed the mark on proportionality, rationality, and predictability. I'm even questioning whether the word uniformity is used in the best or proper way. Uniform sentencing does mean, on a statewide basis, attempting to treat people across the state who have similar criminal histories and who have committed similar crimes similarly. Proportionality means the punishment should fit the crime. It does not seem rational to give everyone the same punishment regardless of the type of offense or a person's criminal history. It does not seem rational to ignore either the other subjects of restitution, treatment, or plea agreements. And I don't think it seems rational to have a felony sanction less than some gross misdemeanor sanctions. This is a statutory conflict that I believe the Commission has now created. Taking away both the legislative and executive branch authority to the judicial branch in this way seems a bit incomplete. And I would like to explore Minnesota Statute 244.09 that Senator Schnell made reference to in an earlier comment. Did I say Senator again? Commissioner Schnell? And a copy for our members is in your packets, 244.09. I've highlighted several sections of the law that I believe to be relevant in today's discussion, particularly subdivision 5. In it, it quotes, "In establishing and modifying the sentencing guidelines, the primary consideration of the Commission shall be public safety. Probation is explicitly listed in subdivision 5 as a sanction and not as a sentence in and of itself, which the Commission has now recognized. The guidelines shall be based also on reasonable offense and offender characteristics. This recognizes proportionality, parity, and it's written into the statute. Putting uniformity first as the perhaps only measure means that the offender's history doesn't necessarily matter, and the crime itself does not matter either. I contend it's not rational to treat all probation as a one-size-fits-all direction, and then treat incarceration as proportional. I hope the Commission doesn't go so far that someday to implement an identical terms of imprisonment for different offenses. And I think there's also a few conflicts and other problems, a number of conflicts that have been created by what I think is caused by the board's action. First, felony subdivision. In 609.135, it states, shall be for not more than 4 years or the maximum period for which a sentence of imprisonment might have been imposed, whichever is longer. This seems to be a direct statutory conflict with the Commission's January proposal. You can find that on page 104 of their report, which is also in your packets, members. Also, in the same statute, 609.135, paragraph B, is the fact that gross misdemeanor probation is capped at 6 years by law, but now felony probation will be capped at 5. That causes another disparity. Many crimes of violence will not be allowed to go over the cap, which will result in more offenders probably going to prison. It would be ironic if more imprisonment is the unintended consequence of what I think was a well-intentioned direction. There's a list of aggravating or mitigating factors for departure for incarceration, but there are none for probation in this proposal. I'm going to stop my comments there, but those are some of my observations and conclusions by what I've seen. We do have a report from the Minnesota Sentencing Guidelines Commission. Director Nate Reitz will give his presentation. Mr. Reitz, would you come to our testifying table?
Mr. Chair, I'm joined by the Chair of the Commission, Kelly Mitchell.
Yeah.
With your permission, she'll lead the presentation.
All right. Chairman Mitchell.
Chair Limmer and members of the Senate Judiciary Committee, thank you for having us today. We really actually welcome the opportunity to talk with you about the work of the Commission and about the proposal that the Commission has sent forward. My name is Kelly Mitchell, and I am the chair of the Sentencing Guidelines Commission. Thank you for pointing out that I forgot to say my name. I am going to actually turn it over to Nate first, and he'll lead us through the report, and then we'll go through the proposal at the end of that.
Good afternoon, Mr. Chair and members. My name is Nate Reitz. I'm the Executive Director of the Minnesota Sentencing Guidelines Commission. Thank you for giving us a chance to appear again before your committee. We've selected 3 topics to discuss with you today in the hopes that they're relevant to what you're looking for. The first, we'd like to talk about the history and structure of the commission itself. Second, we'd like to give you some highlights of the report to the legislature that you have in your packets that we sent to the commission in January, to this committee in January. If with your permission, Mr. Chair, I'd like to delve briefly into some areas that are off topic of the bill, but I'll try to be very brief. And finally, we'd like to go into some detail about the new probation length guideline that the Commission has submitted to the legislature. So first, let's begin with a review of the history and structure of the Sentencing Guidelines Commission. 42 years ago, the Minnesota legislature established the first Sentencing Guidelines Commission in the nation. It gave the commission essentially 6 responsibilities in those charter statutes, and those responsibilities have remained essentially unchanged today. The first 3 responsibilities had to do with the sentencing guidelines. The commission was to establish sentencing guidelines to meet as necessary for modifying and approving those guidelines, and to keep the legislature informed as to what those modifications and proposed modifications were annually. In addition, the commission had some responsibilities with respect to more statewide responsibilities with respect to data and information. It was to serve as a clearinghouse and information center for state and local sentencing practices data. It was required to conduct ongoing research on various matters relating to the improvement of the criminal justice system, and it was required periodically to make recommendations to the legislature regarding changes in the improvement of criminal law and criminal procedure. Let's now spend a minute talking about what those sentencing guidelines were supposed to look like. The legislature required the sentencing guidelines to have 2 main features. First, they were to establish the circumstances in which imprisonment was proper, and I did briefly talk about this on last month before this committee. They were to establish when imprisonment was proper, when those circumstances were, and they were to establish a presumptive prison sentence for those offenders for whom imprisonment was proper. And those were required features of the sentencing guidelines that the commission was required to promulgate back in 1978. In addition, however, the legislature gave the commission an optional grant of authority. The commission was authorized to establish within its guidelines appropriate sanctions for offenders for whom imprisonment was not proper. Such non-imprisonment guidelines could be broad in scope and were explicitly authorized to include probation and the conditions thereof.
So, whoops, it's not up there yet. So what that does then, in a study of the effectiveness of the sentencing guidelines in 1984, the commission said that described that this set up a unique distribution of sentencing authority. The legislatures would establish broad policy standards by defining crimes and establishing statutory maximum punishments. The commission would work within those broad policy standards and develop advisory sentencing guidelines for district courts subject to legislative review. And judges would impose real-time sentences for felons, and with their departure authority under the guidelines, could individualize sentences based on the unique characteristics of the offense and the person being sentenced. There's also an inherent feedback loop in this process that I just want to mention really quickly. The commission regularly reviews the sentences that judges impose, and based on that, we may amend policy, and then the legislature's role is to review the policy that we put forward based on that review.
The commission's structure was designed to represent both the criminal justice system and the public. 3 members, all appointed by the Chief Justice, represent the 3 levels of Minnesota's court system. The other 8 members are appointed or designated by the governor. Two members represent the opposite sides on a criminal court case, the prosecution and the defense. 3 members represent the criminal justice system in effect before and after the court case, police, probation, and the Department of Corrections. And finally, 3 members represent the public, including one who must be a felony crime victim. In the next several slides, we're going to breeze through some highlights of the report to the legislature that we sent to this committee on January 15th. We will be very brief, but we'd be happy to return to discuss any of the issues that we unearthed today at greater length. In each annual report, we take the opportunity to tell you about the Commission's activities in the previous year. The Commission made several changes to the sentencing guidelines in 2019, most notably some changes to the criminal history score calculation, which we reported to you last year at this time. The Commission is also proposing to make changes to the 2020 sentencing guidelines, the most notable of which is the 5-year cap on the length of probation for most felonies, which the Chair has already discussed and which we'll be discussing in a few minutes in greater length. As we discussed earlier, you have invited, indeed required, the Commission from time to time to make recommendations to you on matters involving crime policy. The Commission had one such recommendation in its report to the legislature this year. That is to define a minimum term of imprisonment for people sentenced to life imprisonment for murder of an unborn child in the first degree. So the minimum term of imprisonment was deleted, apparently inadvertently, by the 1989 legislature. This has not been an issue yet because this offense is rarely committed and has always been accompanied by the murder of the mother. But the Commission recommends resolving this problem before it becomes an issue in a particular case. It is foreseeable that there could be a murder of an unborn child without the murder of the mother, and then the minimum term of imprisonment is statutorily undefined. The only thing we know is, thanks to guidance from the Supreme Court last year, it's not life without the possibility of release, but what is that minimum term of imprisonment is entirely unknown. Finally, you instructed the Commission to review how it ranks child pornography offenses last year compared to other sex offenses, and the Commission is currently in the process of conducting this review. The Commission monitors sentencing practices for felony offenders throughout the state. We saw in 2018 a record number of, in 2017 we saw a record number of felons sentenced that year. 2018 was down by 4 cases, so basically flat. So 2017 was a record, and 2018 was very nearly as high. 2018 saw the number of drug cases go down for the first time since 2010, although after years of significant growth, the number of drug cases sentenced in 2018 was still 66% higher than the volume was in 2010. In 2018, for the first time ever since we've been keeping records, women accounted for 20%. They broke that 20% threshold of case volumes for felony cases sentenced. In 2018, 38.3% of the cases in which the guidelines recommended a prison sentence, the offender was instead sentenced to a probation sentence. So that we call that a mitigated dispositional departure. This is the highest mitigated dispositional departure rate we have ever seen. For 2 common offenses, second-degree assault and first-degree burglary, the mitigated dispositional departure rate actually exceeded 50%. As I said before, we would be happy to go into details of the data to include the differences in departure rates by gender, race, ethnicity, and geography at the convenience of the committee. This year's report to the legislature has a special section on the impact of the 2016 Drug Sentencing Reform Act, or DSRA as we're calling it, something the legislature asked us to look at, particularly in the DSRA. We compared post-DSRA cases sentenced throughout 2018 with a comparable group of pre-DSRA cases. We found that the post-DSRA group was significantly larger than the pre-DSRA group, which is consistent with the rise in drug cases that we've been seeing over the past several years. But it should be noted that the difference would have been even more significant but for the fact that many first-time possession of trace amounts were treated as gross misdemeanors under the DSRA, but would have been felonies before the DSRA. Even though there were more cases in the post-DSRA group, we found that the post-DSRA cases required 7% fewer prison beds estimated than the pre-DSRA group. In fact, when we applied 2015 sentencing practices to the post-DSRA group, in other words, we figured out what they would have been sentenced if they had been sentenced the way cases were sentenced back in 2015 based on their drug type and amount. We found that the post-DSRA cases would have required well over 1,000 more estimated prison beds than they did. So we have found evidence that the DSRA both saved and avoided the need for prison beds. Some drug offenses can be enhanced in severity if committed in a school zone, park zone, etc. Although the use of such zone enhancements in Minnesota is fairly uncommon, we found that prosecutors overall, and particularly prosecutors in some regions, have increased the use of zone enhancements after the DSRA went into effect. We also found that stays of adjudication have become more popular after the DSRA changes. As we have previously reported to you, methamphetamine continues to dominate Minnesota's drug scene, comprising 64.5% of post-DSRA felonies. Finally, I'd like to provide the county attorney firearms report. This is not data we have. This is data that's provided to us by the county attorneys by law, and we have to report it to you. So county attorneys have to report to us the disposition of certain types of offenses that fall under 60911's mandatory minimums, where there was allegedly a firearm involved in the case. In fiscal year 2019, county attorneys reported disposing of 1,274 such cases, which is a record high. Of the 767 cases in which the defendant was convicted and a firearm was established on the record, county attorneys reported that the mandatory minimum was imposed and executed in 458 of those cases. And the statute specifically authorizes the prosecutor or the judge or both to waive the mandatory minimum, which is either going to be 3 or 5 years in prison for firearms cases.
So the change that received the most attention this past year was the modification the Sentencing Commission made to create a probation guideline. As we discussed earlier, establishing guidelines for non-prison sentences was one of our original delegations of authority. And there have been discussions over the lifetime of the commission about potential ways to address non-prison sanctions within the guidelines. In the first year, when the commission put out the original set of guidelines, they didn't include probation guidelines or any other non-imprisonment sanctions because they just didn't have the time to do it. If you read the early reports, that's exactly the reason that they cite, the time constraints. They were creating a new sentencing system, they were creating a grid, they were creating a whole new way of doing things, and they ran out of time to do it that first year. But the commission continued discussions. In 1982 and 83, they focused on disparity in jail terms around the state, but the discussion was further complicated by vast differences at the time in the quality and availability of jail facilities around the state, and so the commission ended up not making any recommendations there. In 88 and 89, the commission engaged in an extremely comprehensive study of non-imprisonment sanctions and considered potential models for providing guidelines on jail terms, probation length, and treatment. At the time, the percentage of people receiving prison sentences under the guidelines each year was about 20%. And if you read their report, the commission actually describes the system as 20% determinate and 80% indeterminate because of all of the variation in what was going on in probation sentencing. What you can glean from the reports is the need for individualized sentencing. Probation sentencing is harder than prison sentencing because it involves not just retribution and incapacitation, it also involves rehabilitation, deciding what combination of sanctions and treatment will serve the twin goals of holding the individual accountable for the crime and also promoting rehabilitation so that persons will be less likely to reoffend in the future. To a large degree, many of the contours of that decision are best left to the judge at the individual case level decision. Over the years, probation length has continued to be an issue. It came up again in 2017 when Senator Latz established a work group to study earned compliance, which was a policy option for allowing people to earn their way off of probation. That group was convened over the DOC. The DOC hosted the group. They didn't lead it, but they hosted it. And that group concluded that Minnesota wasn't ready for earned compliance because we had to fix the disparity in probation terms first. It came up again in 2017 and 2018 when the Commission conducted a comprehensive review of its criminal history score and found that the disparity in probation terms around the state was impacting the way that our decay policy works. That's the policy that determines how long a criminal event will remain in a person's criminal history. Some probation sentences had the potential to remain in criminal history longer than prison sentences because of the disparity in probation lengths. These more recent discussions led to the Commission's taking up the issue again starting in 2018. At the same time, there have been discussions here at the Legislature. Bills with bipartisan support have been introduced in the House and the Senate in 2017 and 2019. The bills introduced in 2019 represented an agreement reached by a broad coalition of stakeholders. The House version was passed and included in the Public Safety Omnibus Bill, but the issue wasn't heard here in the Senate. So the Commission has actually been looking at probation for quite a long time. The Commission publishes a report on probation terms annually. And here's what the Commission has learned through that study. First of all, we know that there's wide geographic variation in pronounced periods of probation. The actual amount of time that a person may serve may not be the same as the amount of time that is pronounced. I do want to make that clear. But here's an example. This is just one example. The graph on the slide shows sentencing for probation, the length of probation terms for people who were sentenced for drug offenses 2016 to 2018. And what you see here is that this is broken out by judicial district, and individuals who were sentenced in the 4th and 6th judicial districts, that's Minneapolis and Duluth, received average probation terms of about 3 years, whereas people who were convicted in the 7th judicial district, which runs from St. Cloud to Moorhead along the 94, had an average term of 108 months, which is 9 years. So we know that probation terms vary widely. We also know that most probation revocations, if they occur at all, occur within the first 2 years of receiving probation sentence, and only about 1% of probationers are revoked after 5 years of probation. Now, this is the work the Commission's done. In my day job, I'm the executive director of the Robina Institute of Criminal Law and Criminal Justice, and we have also done some work on probation. We've done recidivism analysis over at Robina, and we've determined that the greatest risk for recidivism for people who are on probation occurs within the first year and a half. So again, that first 2-year period is the most critical for people on probation. It's the time and place where we need to be putting our time and resources to work with people to try to prevent reoffense in the future. It's our best period for impacting public safety. So based on this information, the Commission brought forward the Commission heard a proposal and provisionally adopted a proposal in November. We held a public hearing on that proposal in December. 31 people testified at that public hearing. 63 people submitted public comments, written comments, and a few people were in both groups. Most of the comments that we received were in favor of enacting probation guidelines. Some comments offered constructive suggestions for improving our policy, and a few were negative. Broadly, here's what the probation guideline does. Unless the legislature decides otherwise, the policy will go into effect on for people who are crimes committed on or after August 1st, 2020. There will be a presumptive limit of 5 years for felony probation length. So that means that probation, once it has been determined under the guidelines that probation is appropriate, the term of probation can be anywhere from 0 to 5 years. Judges can depart from this guideline based upon a finding of substantial and compelling reasons to do so. This is the same departure standard that we have for all other sentences that are imposed that are different from what the guidelines recommend. And the guideline does not apply to specified homicide or criminal sexual conduct offenses. And with that, I think we have, that's pretty much the contours of the proposal. I think we've covered most of the information we wanted to in our proposal, and we would stand for any questions.
Are there any questions or comments? Yes, Senator Latz.
Thank you, Mr. Chairman. And Ms. Mitchell, you identified the standard for departure. I know for sentencing, there is a list of mitigating factors or aggravating factors that would be identified as a basis for either mitigating or aggravating the sentence, and there are some factors that are prohibited from being used in consideration to do that. Does this proposal make any reference to those standards as a basis for departure decisions? Or is the basic standard identified as the same but without any of the specific references involved?
Sure, Mitchell.
Senator Limmer, Senator Latz, the guidelines don't, the way that the guidelines are written, in any case where a departure is allowed, they don't specifically reference over to a particular list that can be applied in that case. All of the reasons that exist within the guidelines could be utilized in any case in which a departure is given. There's also a sort of a catch-all allowing, it's a non-exclusive list, so allowing the court to develop additional grounds for departure if that is reasonable. So that just means that the court has to articulate a good reason. So yes, the reasons that exist within the guidelines would apply to this standard, but the court would also have the ability to develop new reasons if there are different reasons for a probation departure that might be more relevant than the reasons that are listed in the guidelines today, if that makes sense.
Sir Latz.
So, Mr. Chairman, Ms. Mitchell, it sounds like what you're describing then is an identical but parallel structure for probationary length alongside sentencing length or decisions. Is that accurate to say it that way?
Chair Mitchell.
Senator Limmer, Senator Latz, yes, that is accurate to say it that way.
Chair Mitchell, if a judge wants to conduct an upward departure, could you tell me how the process works beyond 5 years?
Senator Limmer, if a judge were to want to conduct an upward departure, the way that aggravated departures work today is normally actually the prosecutor is the person who sets that process in motion by notifying the defendant and the court that they wish to seek an aggravated sentence. That puts into place a process where the defendant must be notified of what the grounds are for that aggravation and must be given an opportunity to have the facts that support that departure proven before a jury. We don't know for certain whether an aggravated departure for a probation term would follow that same procedural process, but I would guess that it would need to. And so there would need to be notice of intent to seek a longer probation term. There would need to be grounds for that, and the individual would need to have the right to prove those facts to a jury if they so choose.
So if a defendant wanted to object to an upward departure, there would be another jury? Tell me how that works.
Senator Limmer, yes, that is a process that works today for aggravated sentencing. There's usually a hearing prior to the sentencing phase where the court has to determine whether the facts that would support that aggravated process are so prejudicial that they need to be heard in a separate hearing. Sometimes they are all, those facts are dealt with at the same time that the facts to prove the crime in the first place are dealt with. But sometimes they're more prejudicial and they need to be dealt with in a separate proceeding, which usually occurs directly after the conviction has occurred. In most cases, however, most individuals who are seeking an aggravated, or in most cases where an aggravated sentence is sought, individuals plead to the sentence, and there is actually not a jury trial in most cases. I can't remember what the percentages are, but it's a pretty high percentage.
Are there any questions or comments? Senator Latz.
Thank you, Mr. Chairman. So it seems to me there are a couple of issues here. One is, although it took a few decades, it sounds like the Sentencing Guidelines Commission is addressing exactly the problems that they were set up to address, although this time it's connection with probation length rather than sentencing disparities around the state. And this is what we ask them to do. Now, there were some questions around the process, which I understand, and perhaps we can flesh a little bit of that out here. I think it's worthwhile to say that, and we'll probably learn more in the course of this hearing, but it's worthwhile to say that it's worth not rushing to judgment about the outcome until we hear the full detail of why, or the justification for the outcome, the process, but more importantly, the policy justifications, the data underlying the decision. And so I'm interested in hearing more from those who will testify and participated in the process about this as well. But at first blush from this presentation so far, it sounds to me like it was a rational, data-driven, evidence-based decision, which in its end form completely conformed with statutory and constitutional requirements in Minnesota. It also sounds to me like it was a very rational policy that was ultimately determined by an 8-3 vote, if I remember the numbers right, 8-3, by the Guidelines Commission. So at some point, I would like to hear a little bit more about the process, including sort of the one part of the process that was rushed, for sure, with sort of a last-minute addition to an agenda, but noting that there was no elimination of any required public hearings or input from the public during this process. But I'd like to hear a little bit more about why and how that played out, too.
Senator Latz, was that a question for our testifiers, or is that something you want to get into a little later?
Well, Mr. Chairman, I'm not certain whether there is intended to be a presentation or other witnesses that will address those. Perhaps these witnesses could address those points now, and while they're there, and there's others who will address them, I suspect they might. Fine. We can listen to them at the time.
Chair Mitchell.
Senator Limmer and Senator Latz, I honestly can't remember if it was a month or two prior to the November meeting. I actually made a presentation to the commission. I put the chair, the gavel aside for a bit to make a presentation on the data that we did have on probation length. So we had already been talking about it, and the prior commission had already been talking about probation lengths. And I think that it just got to a point where a member that brought the proposal forward just thought, why are we waiting on this? Why don't we have the data, we've looked at this before, why don't we bring this forward? Now, I will admit, as a new chair, the process was not pretty, and I could have handled that better, and I do take some of the blame for that. But I also think that any upfront ugliness in process, so we rushed it, it didn't quite happen the way that it maybe should have happened at a particular meeting. But the way that our commission is structured, we have a long process of public input for any issue before a policy becomes final. And so that, I think that process cures any defect in the initial way that the proposal may have been brought forward. We did look at that proposal in November. A majority wanted to bring that forward for a public hearing. We did have that public hearing, and as I mentioned, it was probably the longest, most well-attended public hearing that I have ever witnessed at the commission. And I think we had a variety of individuals testifying on this bill, and on our proposal, and we had very few people testifying against it. There was a lot of support for moving forward with this proposal. And the thing that kept driving those of us who voted for it was that we had an opportunity to impact the lives of individuals who were on probation now and not wait another year when we would come to the same conclusion in another year. So it may have been a bit faster than normal, but we did get a great deal of public input. We used that input to make the proposal better and to fit our proposal within the structure of the law the way that it's written now. So I guess that's what I would say now, and others may have additional things to add to that.
Well, Chair Mitchell, Senator Latz raised the question about having enough time to review data. And there may have been discussion prior, but to have a member say, let's just move on it now and get it over with, kind of that almost cavalier attitude, does that negate the opportunity to study more data? Or data, was it ever discussed?
Chair Limerick, are you asking whether the data was discussed, or?
Was the data addressed at the time when the author of the proposal gave the impression that we should move on it now?
Senator Limmer, actually, yes, the data was the impetus for the proposal being brought forward.
Senator Ralph.
Thank you, Mr. Chair. I'm listening to this, and I'm trying to bring it all into the guidelines for the guidelines, universal, proportional, et cetera. What troubles me is what we're proposing here is something that is really a departure, from a true departure from the whole concept of trying to be proportional with the penalty versus the crime. If we were to apply this rationale to the incarceration portion of the guidelines, we would put a uniform cap on incarceration. And I don't think that that is prudent, because the whole idea behind sentencing, and whether it be for probation or for incarceration, is to basically impose a penalty upon someone, one purpose, for committing a crime. And that penalty has several reasons. And if we are going to deprive the courts of the opportunity within guidelines, which we do now, which I must say have worked very well. I was practicing criminal law when these guidelines came in, and everybody kind of shook their head and ran like crazy for the corners. But it actually has proven to work very well. But it did not include any sort of mandatory cap on any kind of crime that fit within the grid lines. So I'm trying to find the reason why we should now depart, even though we are still dealing with criminal penalties, being imposed in the form of a probation rather than an incarceration. The person is still confined within the guidelines of the probation. They are still serving a, quote, sentence. So can you explain to me what the difference would be that we would have a cap on one form of penalty and not on the other?
Senator Senator Limmer and Senator Ralph, yes, actually, I can explain the difference there. When we're talking about a prison sentence, the primary sentencing purpose is retribution or incapacitation. We are trying to impose that penalty. We've made a policy choice based on the severity level of the offense and the criminal history of the individual, how much time would be appropriate for that person to serve in prison as a form of accountability for that offense. When we're talking about probation, it gets messier. Now, accountability still matters in probation. Retribution still matters in probation. But we also firmly believe in Minnesota, and we have ever since we created our Community Corrections Act, that treatment matters in probation. So now we are really seriously considering the rehabilitation goal at the same time that we're considering that retributive goal. And treatment takes different amounts of time. So it's difficult to figure out from a policy level in the middle where we are at the commission to figure out how much time is necessary for that treatment. So actually, by giving the courts a range of 0 to 5 years, we're giving them more flexibility to determine what the appropriate amount of time would be to not only serve that retributive goal, make sure that they're held accountable for the offense, but also to meet the goals of rehabilitation, to have enough time to complete treatment. So that's what's different about it. And so the guidelines are still going to tell us who deserves probation versus prison based on the severity of the offense and the criminal history of the offender. But then we need the judge to tell us underneath that how much time is appropriate for that rehabilitative aim. However, we don't need so much discretion within the courts that we have probation terms that range from 3 years to 10 years. We don't need that much of a range. We need something a little bit smaller than that. So I think this guideline strikes the balance there. It gives the court the flexibility to set that appropriate probation term, but not so much flexibility that they can go well beyond the 5 years without justifying it more based on the information that they have at the time of sentencing.
Sarah Ralph, we'll have one more question and then we have to move on.
Thank you, Mr. Chair.
And then, Senator Ralph, after a bill is presented, then we can have this more in-depth discussion.
I guess I would just ask the question, however, if the intent of a sentence, whether it is probation or incarceration, you seem to be confining it to the rehabilitation and accountability. And I think we're forgetting one thing, and that is a sentence or a penalty for a crime has other purposes, one of those being deterrence. And I think if a person looks at a crime that they're going to commit, depending on the nature of the crime, the deterrence may or may not have an effect. But it's something we can't ignore. And if we change what the legislature has decided is an appropriate penalty to help deter a person from acting that way in the first place, if we depart from what the legislature have done, we're defeating part of that purpose. And this is why I am concerned that we are not looking at the underlying reasons for, first of all, sentencing, but secondly, the guidelines themselves, because the guidelines still worked within the framework of the legislative sentencing guidelines set forth in the statute. Now, it seems to me that a better approach to this would be to create a grid, much as you use for incarceration, that would take into account the same factors and could even add other factors if necessary to arrive at a range of sentences. But to arbitrarily cap the penalty when the statute does not really provide for that seems to me to be problematic, especially when you end up having some felonies having a shorter probation period than gross misdemeanors. And I think there's a total lack of rationality there. Thank you, Mr. Chair.
Thank you. I think we'll move on to, were you asking for a response, Senator Ralph?
Well, if there is a response, I would welcome it.
I think what we'll do is, there's plenty of time for discussion afterward. We have another testifier that wanted to give testimony on the bill, and I think we'll move right into the bill. Thank you for giving testimony. I hope you can stick around for the discussion.
Senator Limmer, whenever you're ready.
Thank you, Mr. Chairman.
Senator Limmer, do you want to have us look at the A2 amendment first?
I was just about to say that, Mr. Chairman.
We need
As
that.
we begin this bill presentation, I'd like to offer an author's amendment, the A2 amendment.
Okay, members, that will be passed out to you.
Mr. Chair.
Senator Anderson.
Okay, I was just questioning to see if your microphone was on. I couldn't quite hear you.
Okay, it is. Thank you.
Thank you.
Members, Senator Limmer has the A2 author's amendment. So all in favor of the A2 amendment, say aye.
Aye.
Opposed? The A2 amendment is passed. Senator Limmer.
Thank you, Mr. Chair. Section 1 of the bill removes the authority from the Commission, the Sentencing Guidelines Commission, to promulgate rules on sanctions other than prison incarceration, at least for the time being, putting a pause on that duty. Section 2 allows the Commission to gather probation data. This is something I'm personally interested in and learning more about, and do not believe probation modifications are wise to enact quickly or emotionally, but instead should be done with full information over a period of time. How are we to make informed decisions if we only hear anecdotal evidence from a few people but do not actually have information that shows us a wider perspective and with statewide statistics? One of the very important pieces of data no one seems to be talking about is what is happening in our real world in terms of early discharge of probation. Are there quantifiable results? What do other states do? Do we have advice from other practitioners? If people are released from probation early under current law, which is authorized in many cases, that has not been part of the discussion. That has not been part of the discussion that I've heard. I think we should have hard data on what is actually occurring. I agree with Senator Latz on studying data, particularly from places other than just the districts that have implemented their own kind of artificial cap on probation. If it's possible to work within judicial districts to use more of the tools currently available to them, then that's an option probation reform advocates should seriously look into, district by district. Sometimes, when we have a far-reaching reform proposal, that type of top-down direction oftentimes creates resentments or difficulties in understanding on the lower levels. And it might very well thwart some of the intentions of people working for change. Instead, using tools already available, working with judges and attorneys, I believe can get you a better result. And practitioners will know they've been included and will create a sense of buy-in. Just as importantly, there's been a lot of talk about probation revocations by Commissioner Chanel and others that are apparently including planning to reduce Minnesota's prison population by 20%. This was a direction that Commissioner Chanel was looking into, many of which they claim are technical violations. Gathering this data is just as important for us to understand the conditions of probation that were broken in the first place, the very ones that caused the revocation. Collection of probation data was discussed at the Commission's February meeting. In your packets, there's a February 24th memorandum from the Commission that outlines their recommendations that the Legislature authorize collection of probation data. And I believe that the Commission would support Section 2 in this amendment, or this bill. Section 3 would add to the annual report to the Legislature a section on probation. It makes sense to have the Commission include the data from Section 2 broken down by judicial district in the annual report. We receive that Commission report every January. Section 4 rejects the January modification the Commissioner has proposed regarding probation, and they would not take effect August 1st of 2020. Again, based on the workmanship, the concerns, I think the lack of complete hard data to consider for full enactment, this proposal needs a little bit more work before it's ready for prime time. Section 5 requires a real probation proposal from the Commission. I believe a comprehensive proposal serves the public best. It does not require piecemeal changes to either the guidelines or statutes in years to come. We should use the data that is now going to be collected to tell us what the real problems are, and not just rely on anecdotal stories or statistics from one judicial district without taking the entire state and all the districts or Minnesota districts into account. I believe we want the Commission to actually take proportionality into account when it comes to probation and not return with a one-size, 5-year, one-size-fits-all probation system. I believe we want the Commission to show us something like GRIDS, as Senator Ralph mentioned. Perhaps GRIDS is not the exact model. We see it in other areas, especially as we apply it toward incarceration. We want the proposal to be rational, logical, well-reasoned. I believe we want the proposal to not have conflict with current law. I think we want a proposal that takes into account plea bargains, upward departures, and criteria judges are to use to do them. That means we would allow a little bit more judicial discretion. I believe we want a proposal that allows for longer periods of time for treatment completion and restitution repayment. We want the Commission to take their time and use their expertise to be put to good use and come back with a proposal that actually works and is complete in regard to the entire criminal justice system. The Sentencing Guideline Minority Report needs to be recognized as well. Those pages are in the annual report to the Legislature, but I can't talk about sentencing guidelines proposals without mentioning some of their observations as well. Here are some quotes from the Minority Report. quote on page 107, "The proposal is unworkable and may actually increase Minnesota's incarceration rate." Second one, on page 109, "The presumptive probation length entirely ignores offense severity and criminal history in its application. In every case in which the presumption applies, a 5-year length of probation is presumed to be appropriate regardless of offense severity or criminal history. That approach is the antithesis of the principle that the severity of the sanction should increase in direct proportion to an increase in offense severity or the convicted felon's criminal history or both." On page 10, the comment is, "In sum, the majority's proposal replaces one unacceptable disparity with another." So, in conclusion, this issue has not been, it's not been secret. It's been a little bit out in the open. It's discussed in outside, it has been discussed in outside discussions and observations for years. We have often heard that sweeping reform takes time and that it needs to be done right. The Commission could have taken note and worked on it in June, July, August, September, October, but the members did not, at least in a public discussion process. They waited until the last few months. And quite honestly, I think they've been attempting to fix some of the issues that have been raised in February. I would hope that they won't be fixing things in the next month. As a legislature, we may very well be amending these statutes for years to come. I just think we need to pause. I think the Commission needs to pause. In the meantime, I honestly believe we could be running the risk of putting some of our public members, our citizens, in danger due to some of the decisions that have been made. I'm not quite sure if our citizens or crime victims have been heard on this. I was at the public hearing. I made comments at the public hearing, but I didn't hear too many people from the victim category. There is one member, by the way, on the Commission that's a victim, I believe. But I do hope you would support in rejecting the Commission proposal while instructing them to collect data on which we can make reform possible in this area of law. Mr. Chairman, I do have a testifier that would like to come forward at this time, too.
If the testifier would find a chair here at the desk. Welcome to the committee, Justice Dietzen. If you'll give your name first and your testimony.
Yes, Mr. Chair, members of the committee, as was stated, my name is Christopher Dietzen. I'm the Chief Justice's designee for the Minnesota Sentencing Guideline.
Justice Dietzen, could you pull that mic a little bit closer?
Oh,
directly
all right.
at you?
I'll try and
Thank you.
swallow it if I can.
Yeah.
All right. All right.
Continue.
So I have some prepared remarks that I'll just try and quickly go through and hopefully make this more of a interactive, that you can ask me all the questions you want. As I understood it, I was to participate by discussing my memo and Judge Larkin's memo in December 4th regarding procedural irregularities before the Sentencing Guidelines Commission that led to the adoption of the probation caps now before the committee, and a memo of March 4th of this year from 5 members of the commission requesting that the commission recommend to the legislature that you direct us to study and adopt presumptive probation terms for all felonies except homicide and crim sex cases subject to departures for aggravating mitigating factors. Thank you for the opportunity to address you on these topics. With respect to the procedural irregularities, I know you've seen our memos, and so I don't want to belabor what happened, but let me just say this. Based on my review of old records and talking to prior chairs of the commission, for the past 15 years, the commission operated on a well-defined set of informal rules to ensure that it conducts fair meetings in which the commissioners and all stakeholders have an equal opportunity to participate, and encourages us to build consensus. And those sort of three rules are that we publish our agenda, it's available online, it's given to the commission members 7 days before the hearing. The agenda has, for each item on it, a designation of either for your information, discussion, or action items, so that the commission members know ahead of time which matters they're going to be asked to vote on so that they can prepare. And the other sort of rule, and maybe I'm skipping one, I apologize, but the other rule was I call the first reading rule, that whenever there is a proposal to amend or modify the guidelines, that there would be a first reading and a discussion and no vote taken, to allow everyone the opportunity to discuss and think about it, and then to noodle it, if you will, for a month before the next meeting. That's not what happened here. What happened here is literally hours before this matter was presented to the commission, there was a probation proposal. Now, we are told, or you were told, that this has been on the discussion block for many, many years. And I think that may be fair to say if you say that, have there been general discussions? Yes, there's been general discussions. We've been discussing drug sentencing reform for over 20 years, but there was no active intent to address probation duration reform until that November meeting. That's the first time we had a proposal. So from my perspective, just from my perspective, I was blindsided. I didn't know that this was coming. I didn't understand that it was going to happen. Now, the reason that rules are important is so that you avoid this type of thing and everyone has the same starting place. When this was debated at the November meeting, the majority's justification was that three of the new members of the commission had not heard of these informal rules and therefore didn't feel bound by them. And the majority wanted to adopt the resolution quickly to qualify under MnStat 24409 subdivision 11, so that this was a self-executing modification to the guidelines, meaning that it was only subject to legislative override. My purpose of my comments is to say that, I can't change what happened here, but what I think is important is that we recognize the importance of having rules, having a procedure that we can all operate under, and I have asked the commission to adopt rules and go through a rulemaking procedure so that this doesn't happen again, because the minority, and I think we say it in the minority report, felt that we were not given a notice that this was going to go forward. There was, that we were prejudiced, and as a result, the stakeholders and the public, I think, were prejudiced as well, as particularly, I think the other point that I want to make is that if you step back and look at it, if this had been a more deliberative process, I think it's obvious, at least to me, maybe not to anybody else, but to me, that we would have been able to have a discussion about the proposal that I wanted to have considered, which was presumptive probation term, a grid where we had a presumptive duration for all felonies. Because if you go to the merits, and now I'm leaving the process, if you go to the merits of the proposal, I think there's significant problems with having caps. And I think that the problem, the first problem is, as Senator Limmer mentioned, it's a one-size-fits-all kind of problem. The second is that we, in terms of the way the statutory intent, and in terms of the statutory framework, the way it's developed is having for each crime a presumptive sentence or a presumptive range, and that's in a general grid. It's in the drug sentencing grid, the crim sex grid, and it makes more sense to me, and I think to other members of the commission, to do the same thing with probation terms, that if you're going to set policy for those probation terms, then we need to study each one of them one by one, and we need to have a presumptive range of a probation term for each offense that takes into account the offense and the offender characteristics. And the problem that we saw with the bill, or not the bill, but the modification that's before you, is that there are no aggravating factors that apply to probation, and that presents a problem for judges. As a judge, you look through that aggravating factor, and the lawyers will look at the same thing. It doesn't set forth what you're going to look at to depart upward. What are the aggravating factors that would apply? When we debated the issue, there was a recognition by the majority, several members of the majority, that was true, and that what we were going to need to do is let the judges develop this and let them figure it out. And my response to that is that I think it's the Guidelines Commission to set the policy if we're going to go that direction, and we should determine what the aggravating factors are going to be that allow a judge to say that there are substantial and compelling reasons for departing upward in a particular case from the presumptive range. And I know that I've touched on a lot of broad topics, but I wanted to make the 2 points. One is that I do think that the commission needs to adopt rules that would apply to this type of situation so that it doesn't happen again. And I also think that a presumptive probation term grid is far superior to having probation term caps. And I'd be happy to respond to any questions that the committee may have on those 2 topics. Thank you.
Thank you. I wonder if there are any other, before we move on, any other testifiers that would like to speak on the bill? Okay, if you'd introduce yourself.
Thank you, Mr. Chair. Good afternoon. My name is Lars Negstedt. I'm the Policy Director for Isaiah. Isaiah is a statewide organization of congregations, clergy, and people of faith working for racial and economic justice. So I wanted to add a few things to the conversation. Obviously, several of these points have been made, but just to lift up, Minnesota has the 5th highest rate of people under correctional control, under government correctional control in the United States. That's because of how many people are on probation and in some cases how long these probation sentences are. These rates vary widely across the state. We heard testimony from a young woman who'd been sentenced to 40 years of probation. That's an awful long time to be on probation. At the same time, we've heard testimony from probation officers that caseloads have increased over the past several years. That means they are struggling to provide the kind of oversight and guidance needed to help people on probation get on a better path and stay out of, or get on a path of rehabilitation. In December, we heard testimony from 31 people. 28 of those 31 people in that 4-hour-long public hearing at the Sentencing Guidelines Commission, 28 of those testimonies were in favor of the probation reform. This included many impacted individuals, their family members, social service providers, survivor advocates, faith leaders, and academic experts, as well as practitioners. That vote that took place, the 8-3 vote at the Sentencing Guidelines Commission, included the county attorney representative, a judge, probation officer, and the victim representative on the Sentencing Guidelines Commission. So there's very broad support. We were very pleased to see that Senator Chamberlain was the chief author on 2 bills moving in this direction, including Senate File 1606, which was introduced over a year ago and unfortunately not heard in this committee last year. We think this conversation has been going on a long time, and the real human impact is having serious consequences to people's well-being as well as our public safety collectively. So we hope you'll consider that urgency when you consider this matter. Thank you for taking the time to listen to my remarks.
Justice Dietzen?
Yes, I wanted to respond briefly to the last testifier's comment. When we did the drug sentencing reform several years ago, we had, I think, more witnesses, longer hearing, and I know what people go through. And so I just want to say that, I mean, this does affect people's lives, and it is very important, and I commend him for his comments. The other thing I would like to say is that what we determined, particularly what I determined, was that probation duration data is mostly anecdotal. We did not have we did not have scientific data as to how long these probation terms were actually served. And I think that it would benefit the commission greatly if we were given the authority to collect that data so that we could really drill down and figure out what's going on. We have anomalies in what happens that we have to be careful of, and that is, I'll give you an example. And Senator Latz, I know that you represent clients in the system, and you would recognize this, that those terms that go more than 5 years, from what I've heard anecdotally, and it's anecdotal only, so it's not hard data. I'm not trying to make it sound better than it really is, but it's based on a situation where a judge is faced with a case where there's a presumptive commit to prison. And that judge wants to give the offender a break. And so the break is, I'm going to not execute the sentence, I'm going to depart dispositionally, but in exchange for that, you have to agree to a longer probation term. And that happens, I'm told, from the County Attorneys Association with some degree of regularity. When we put a 5-year hard cap, and because we don't have aggravating factors, my argument is this is a hard cap. What's going to happen is that judges are going to be reluctant to depart dispositionally when the cap is going to be 5 years instead of a longer period of time. Now, does it make sense to have a probation term go more than 5 years? I don't honestly know the answer to that question, but I know from talking to others that a lot of these offenders are, in the swirl of all this is addiction to drugs and alcohol, and there is treatment and failure and retreatment, and that finding a program, and that oftentimes goes beyond 5 years. And we need to have the flexibility to give the judge the discretion to go beyond that 5 years, and it has to be something that is practical, that is workable in the judicial system.
Thank you. Before we go to testimony, I've got a couple things that I'd like to say and questions that I wrote down. First off, a concern is that Hennepin County has stated that in their own volition, their judges have an unofficial probation cap of sorts. And my question is, how does that work, and is that permissible in statute? So that's my first question. In light of the idea of bringing people together in the interest of consensus, have commission members and criminal justice partners or proponents of probation reform considered grassroots efforts to bring change from the ground up in each of the judicial districts? And my last question, would public defenders work with the county attorneys and judges in districts where there are imposing longer probation lengths to move towards more of an organic cap within each district? And with that, Senator Ralph, did you have a question? Oh, Ingebretson.
Thank you, Mr. Chair, and I also have some concerns here, and the list of crimes specifically in the annual report on page 105 on probation caps. It's on page 105 of the 2020 annual report to the Legislature. Basically, it's murder and some other criminal sexual conduct crimes. Does the commission not care, I guess, is a question about serious crimes. Now, there's quite a list. There's an awful large list here of exclusions on page 105 that seem to be quite serious crimes to me. So it really makes no sense whatsoever. Just to name a few, and I'm wondering if the committee might agree with this. You have assault, you have criminal abuse against a vulnerable adult, you have aggravated robbery, kidnapping, sex trafficking. Sex trafficking has been something I think that we've all been concerned about in the last few years, working with, I know, Senator Pappas on some legislation here in St. Paul some years ago. Kingpin level drug dealers, I mean, we're not even going to throw them in the mix here. Arson, stalking, and harassment. Why would we take away the tools from the prosecutors and the judges to get longer terms of accountability in these and other serious felony cases? I guess it's just a question that I have, especially in light of the more serious crimes that have been happening here in the state of Minnesota.
Senator Johnson.
Thank you, Mr. Chair. Appreciate that. So that's interesting that you read off the list of crimes that are going to be probation capped. My guess, not having, worked before the judge before, is that a judge would naturally just start committing more to prison terms if they're limited on their probation. You know, if you're looking at kidnapping, sex trafficking, those sorts of things, and you're limited to a 5-year cap, that's quite a, you know, from a judge's perspective, I would think that you would go that direction, increasing the incarceration rate, and that's one of the reforms that has been mentioned. We want to try to reform. You know, in those felony cases, you know, there's a few that don't fit in there. A judge could give a long probation right now. It seems like a lot more flexible. So a judge could be a lot more flexible in the current system, addressing some of those needs, which to me seems like the appropriate response to what's going on. So this change is very poorly thought out, and I think this proposal is kind of a mess.
Senator Ralph?
Thank you, Mr. Chair. I made some comments before that I think kind of provided a bit of a segue into the bill that we're working with, and I'd like to follow those up a little bit further. It seems to me that this imposition of an arbitrary, and I know there's been some study as to, well, the fact that maybe after a couple of years they're not going to be likely to be revoked. But the thing that concerns me is again, there is such a broad range of criminal penalties that we have in the statute. And it appears that the commission did not thoroughly examine the various interplay between crimes, attempted crimes, and I'll get to that in a minute, and there's no clear direction for judges to know when to depart. Now, the statistics on probation lengths that were present a problem. They show that there is a disparity, and I think that's something we should address. There's no question about it. But I think it should be addressed in a way that is formulated by looking at what the legislature has set forth through its legislative process in terms of the penalties that are to be imposed for the commission of a particular crime. And to try and have a one-size-fits-all where there are a lot of all. There's a lot of places where judges will need discretion. There are a lot of places where the guidelines should do what their original intent was, is to provide guidelines. That was the intention. I do have the concern that there are no clear directions at this point for when a departure can take place. So there's some technical questions here. I know there was a case not too long ago that kind of dealt with whether you actually had to have a upward departure, have to have a separate hearing on it. So are we going to now start to have separate hearings on this? And again, without getting too far into the technical aspects of it, I think this particular change could raise the possibility of significant problems with the courts in terms of how they do depart. So I just think that we do need the guidance, because leaving it entirely up to the courts, while it might have some attractiveness to some, I think they do need some ranges within which to work. But I think to handcuff them completely with this kind of a cap is going to really remove judicial discretion from the penal system. And I think it's very important that we maintain that idea so that we can do what penology is supposed to do, and that is deter, rehabilitate, repay the debt to society. Those are the things that we really want to do. And I think it's going to be harder for us to do that if we are now constrained within what we can do have as a tool for the courts to work with. Thank you.
Senator Anderson, and then Senator Latz.
Thank you, Mr. Chair. I appreciate the opportunity to just comment on the proposal. You know, this current proposal does not seem to address any situations where an offender needs time to complete treatment or to pay back restitution. And treatment and restitution, as was handed out here, Minnesota Statute 244.09, in this proposal doesn't seem to take that into consideration when we look at what the statute says. And if we look, as Senator Ingebrigtsen mentioned, that on page 105, the guidelines themselves state that for state sentences, there's several objectives that must be met, and was mentioned already: deterrence, public condemnation of criminal conduct, public safety, rehabilitation, restitution, retribution, and risk reduction. And it seems like the uniformity in this probation sentencing was far more important than any of these other things mentioned. Seems like there's really no interest by the Commission to deter crime or to publicly condemn any criminal behavior, or to remember that the victims and what their crimes were that they had committed. And this is a concern. I would imagine that it would be not only a concern for me, for the members of this committee, but also a concern for the people of the state of Minnesota. So thank you for allowing me to make comments and to at least bring up some thoughts and ideas of where this proposal should be rather than where it is right today. Thank you.
Senator Latz.
Thank you, Mr. Chairman. I got a couple thoughts and some questions. I'm trying to figure out what this bill would do here. But I have to say, whatever the Commission did here, I don't think says anything about their interest in deterring crime or publicly condemning criminal behavior. I think everyone in this room and everyone on the Commission would condemn crime, or would seek to deter crime and publicly condemn criminal behavior. I think this is a more a different level of discussion on what mechanism within the law would best accomplish those goals. And we've had those discussions in this committee for decades, and they will for decades after we leave. As more data is gathered, more experience is learned. So I don't think I'd paint with quite that broad a brush as Senator Anderson just did. But I have a question, just to circle back on the other part of Senator Anderson's comment. Concern, it's been brought up by others too, about perhaps the amount of time needed to complete treatment or to allow restitution to be paid. And I'm not sure who would be the appropriate person. Perhaps Chair Mitchell would be the right person. But under the Commission's decision here, would those two concerns be permissible grounds for departing from the presumed 5-year probationary term upward?
Chair Mitchell.
Chair Hall and Senator Latz, I'm not sure if they would be grounds for an upward departure. I think it would. I think that especially for having a longer time for treatment, I think the court would have to evaluate that and determine if more than 5 years would be necessary. But what I do know for certain is that the law already allows probation to be extended for both of those reasons. So what our proposal did not do is we did not change that existing law. So if the person is reaching the end of their probation term and they have not been able to complete treatment and they have not finished paying their restitution, there are provisions in 609.135 that allow the court to extend the probation term to allow both of those things to happen. So for certain, I can say for certain that that has remained intact.
Senator Latz?
So, Mr. Chairman, it seems to me, first of all, that's more than adequate to address the concerns. The judge could look at the situation and extend probation if necessary to facilitate additional or completion of treatment and payment of restitution. Second of all, at least from my own knowledge, the longest treatment program that I'm aware of in Minnesota, I might be off on this, but I think it's Minnesota Adult and Teen Challenge, which has a program, a residential program that lasts 13 months. It might be something longer than that somewhere, and certainly there are people who go through a program it doesn't take, it doesn't hold. If they're on probation for 5 years and they aren't able to remain abstinent for 5 years and they end up back in treatment, and so on. But then the part of the question becomes, do you leave someone on probation for 20 years because their periods of abstinence don't last as long as the full probationary period? Are public resources best set under those circumstances? But it seems to me the current structure would address the concern about completing treatment. Unless we're just going to put everyone who's got an alcohol or drug problem on lifetime probation with an abstinence condition, and whenever they fall off the wagon or fail to remain abstinent while they're on probation, so we can force them right back into treatment again anyway, without having committed any new crime. So that's my comment on that point. I have to say that, Senator Ingebrigtsen and Senator Johnson, I think, misread the terms that were on page 105 of the Guidelines Commission's report, because it sounded to me like the senator's comments were suggesting that the 5-year cap applies to those serious violent crimes listed in there. But my understanding was that those are the exceptions to the presumptive cap. So while other crimes would be within the 5-year presumption, these, murder, criminal vehicular homicide, murder of an unborn child, the crim sex cases listed there, would not be included in the presumptive 5-year cap. Either Justice Dietzen or Chair Mitchell, am I reading that correctly?
Yeah, there are specific carve-outs from the application of the rule. Of the modification, yes.
I'm having a little hard hearing you. Can you speak into it?
I agree with what you just said,
Okay.
Senator Latz. I believe that's correct. I'm not sure that, I hate to open this door and quibble with you, but I think the treatment issue, I agree there's an existing statute that would cover that, but it's still subject to a 5-year cap. And so what happens is you'd still need an aggravating, you'd still need to depart if you went beyond 5 years. And I know from talking to judges in Hennepin County, they do talk about 3.5 years. But when there's treatment issues, they have the offender come into court and agree to extend beyond that time period. So I think that there are rules and exceptions, and to the one that you were just talking about, my understanding is that 5-year cap is a hard cap unless there is a specific aggravating factor for the judge to depart.
So members, just to let you know, we're going to have to come back tonight if we don't wrap up here in just a few minutes. Senator Limmer, do you want to respond?
I think Justice Dietzen said the very thing that I was going to ask our counsel to confirm. Perhaps counsel could confirm the reference on an extension and how it affects a cap, or is it a 5-year cap as well?
Mr. Backus.
Mr. Chair and members, perhaps this is subject to debate. If you look at page 105, the guidelines proposes that extensions of probation are governed by statute, and they give 2 statutory references, and those are to the statutes that would allow an extension for failure to pay restitution, you can get a 1-year extension and then another 1 year, and I think that would be it. For treatment, it would be an extension of up to 3 years. I guess the way I interpreted, initially at least, the guidelines language, and I think that would be Ms. Mitchell's belief, is that it would allow you to go beyond 5 years under those two circumstances. The language, I think, speaks for itself. It would have to be interpreted, but that would be my interpretation.
Senator Latz, I didn't mean to cut you off. Do you have more?
No, thank you, Mr. Chairman. Justice Dietzen, if I might ask you a question or two, it sounded to me like you agree that there's a significant problem with the existing way in which the probation is assigned around the state. And the question is, what's the appropriate remedy rather than is there a problem? Am I understanding that correctly?
Justice Dietzen?
Yes, Senator Hall and Senator Latz. If you eliminate the word significant, I would agree with your statement. I think 82 or 83% of the probations that are given fall within the 5-year term, roughly. And so we're talking about a 17% that are outside that 5-year period. But the problem, and the reason I'm hedging a little bit, is we don't have hard data. We have, for example, in Stearns County, there was a person who received a 20-year sentence, but then was released from that after, I think it was 3 or 4 years, because they had complied with probation. So all I'm saying is there's a difference between what's on paper versus what actually happened.
Senator Latz?
Thank you, Mr. Chairman. And then I understand, Justice Dietzen, you clearly would have preferred a different outcome, a different result by the whole commission. But it sounds to me like, well, let me ask you, would you agree or disagree with my earlier summary of the commission's decision that what was created was an identical but parallel structure to the sentencing guidelines? What was created for probation was an identical but parallel structure.
I don't think that I agree, Senator Latz. I want to try to agree with you.
I'm just trying to determine your
Yeah,
approach. I'm not trying to tell you how.
What I get, maybe I should put it this way. What I'm saying is a parallel system would be to create a presumptive probation term grid that had presumptive terms for all the offenses rather than having caps. Because I think that is consistent with the guidelines. I don't think the current proposal is consistent with the guidelines.
Okay.
Is it a step in the right direction? Yes, I think it's a step in the right direction, but it's going to, in my judgment, cause more problems than not.
So, Mr. Chairman, I know we're very short on time, so I'm just going to wrap up my thought. I think some of the comments that have been made seem to focus on the original proposal of a hard cap rather than focusing on the final decision by the Guidelines Commission of a presumptive cap with a number of off-ramps to extend probation beyond the presumptive cap. That's why it's called presumptive. It's a presumption which is rebuttable and can result in a different outcome if the substantial and compelling circumstances are determined to be in effect. There were at least 2 months of opportunity for public input and comment and deliberation and alternative plans to be presented. And what the Guidelines Commission ended up with was a very strong endorsement of this decision, an 8-3 endorsement. I think we should not take that lightly, even though the original proposal had some difficulties with it. Those were addressed. And at least addressed to my satisfaction as to what I think would be the right outcome. You'll leave the judges with substantial discretion, not unfettered discretion, but it provides real guidelines. And if the data is that only 1% of those probation revocations occur after 5 years of probation, we've got pretty tight constraints on 99% of people. They're complying with probation within the 5 years. So it seems to me we got a pretty good setup, and there's, I think, a fair intellectual disagreement on whether a grid system would be a better approach to it, but that doesn't seem to have been the decision of the Guidelines Commission. And also, frankly, this doesn't stop the Guidelines Commission from revisiting that question if they were to determine grid might be a better approach down the road and as more data is gathered. I don't want to get too far into the data adequacy at this point. We don't have the time for that. But I think the legislature delegated to experts a decision on the power, the authority to make decisions and recommendations for a reason. It's because we'd have the limited time by other committees coming into our room. We couldn't spend the entire legislative session digging through all of this, and none of us, frankly, have the level of expertise, I don't think anyway, that the Guidelines Commission has on these kind of things. So I'm satisfied that the process was, while perhaps not ideal, was substantial enough to pass muster, and they probably learned some things about the process as well. But the outcome is one that I think is a meritorious outcome. I don't think it merits us attempting to overturn it with the proposed legislation. Thank you, Mr.
Senator Limmer,
Chairman.
do you want to move your bill?
Yes, Mr. Chair, but I do have to make a few comments. First, in addressing the high number of people on probation and the duration of people on duration is somewhat of a product of our history. As many people know, Minnesota is ranked in some cases the second lowest incarceration state in the country. And as a result, we as a state have relied on probation, hence the need to have more people on probation rather than on or in an incarcerated cell at a high expense. That is a product of our history. Also, the duration on probation is also the very same product. We did not rely on incarceration to put people, rather than put people in incarceration in a prison cell. As for the probation term of a 40-year duration, that is not typical of probation. We have heard this one example used to defend that argument for a few years, but it is not typical in Minnesota's probationary terms. There are a few people that I believe are on a probation term. I believe one had a choice to be either incarcerated for a much shorter time or to choose probation, and that individual chose that 40-year term. Now they want a change. I do want to emphasize judicial discretion is severely being limited to this 5-year window. It has been a practice of this Judiciary Committee, regardless who have held the chairmanship, that judicial discretion is honored and respected and encouraged in our public policy. This goes in a different direction altogether. I do want to make one comment. We've talked about murder and sexual assault not being included, but I want you to think about this. In 5 years, someone could be off paper for attempted murder, attempted rape, attempted kidnapping. Try to explain that one back home. I think that's important to consider. I think the 5-year window, as outlined by the Minnesota Sentencing Guidelines, needs a little more work before we initiate it into our entire public policy in this state. So, Mr. Chairman, having said that, Senate File Number 3975 as amended, I would recommend to pass and move to the Finance Committee.
Members, Senator Limmer moves that Senate File 3975 as amended to be passed and move to finance.
Mr. Chair,
Yes.
I move that we have a roll call vote and that the results be placed in the Senate Journal.
Roll call is requested.
Need 3 hands, Mr. Chair.
Need 3 hands. Okay, 3 hands I see. If you'll take the roll.
Senator Limmer,
Aye.
Senator Anderson,
Yes.
Senator Dietzick, Senator Hall,
Yes.
Senator Ingebrigtsen, Senator Johnson, Senator Latz,
I vote no.
Senator Pappas, Senator Ralph.
The votes being 6 yeses and 3 noes, the motion passes. The bill passes. With no further business, this meeting is adjourned.